Formation of a contract. When discussing the formation of a contract, it is noteworthy as well as beneficial to discuss bilateral and unilateral contracts. So what is a bilateral contract? A bilateral contract is when all parties assume an obligation under the contract. For instance, in a sales contract, the seller promises to deliver a product and the buyer promises to pay a certain price. Therefore, both sides have mutual promises. What is a unilateral contract? A unilateral contract is when only one party assumes an obligation under the contract. For instance, a company might offer a reward for finding a lost pet. The company makes the promise of the reward, and anyone who finds the pet performs the act of acceptance. Therefore, only one party makes a promise in exchange for an act by the other party. And now we're going to talk about offer. But before defining what an offer is, it's best to briefly note and explain what an offeror is and what an offeree is. An offeror proposes terms and an offeree receives them. An offer is a statement of the terms on which the offeror is willing to be bound. Therefore, the proposal creates a legally binding agreement if accepted by the offeree. A leading scholar in contract law, Firmstone, stated that the offeror must have completed his share in the formation of a contract by finally declaring his readiness to undertake an obligation upon certain conditions, leaving the offeree the option of acceptance or refusal. A brief breakdown of Firmstone's views consists of there being apparent intention matters. He emphasizes that offer is judged based on how the offeree would reasonably interpret the communication, not necessarily the offerer's true intentions. Commitment level is also key, as the language used is very important. Disclaimers such as quote-unquote no obligations can weaken the offer's strength. Therefore, the offer needs to show a clear commitment to the terms upon acceptance. And lastly, the importance in specifying. The offer needs to be clear and specific about the terms of the contract, such as the price and goods in a sale. In contract law, there is a clear distinction between an express offer and an implied offer. An express offer is an oral or written form of communication which presents the terms of a contract and clearly states the offerer's intentions to be bound by them upon acceptance. For instance, Sarah telling Mike she will sell him her car for £6,000. This can also be implied by conduct. An implied offer, on the other hand, does not consist of direct statements or terms, but is instead through the conduct of those involved. In other words, when the behavior of individuals suggests they've agreed on something, even though they have not written it down or spoken about it. So for instance, taking goods to the cash desk in a supermarket is an implied offer to purchase those goods. When it comes to offers to the public at large, it is very important to discuss the key case of the Carlyle and the Carbolic Smokeball Company of 1893. So in the case of Carlyle and the Carbolic Smokeball Company, the offer was that the Carbolic Smokeball Company advertised a reward of £100 if anyone using their product as directed still caught the flu. The acceptance was that Mrs. Carlyle used the product as instructed but still got sick. The dispute was that the company refused to pay, arguing that the advert wasn't a serious offer. So the court ruled in favour of Mrs. Carlyle, as the advertisement was seen as a clear offer to anyone who met the conditions. By using the product, Mrs. Carlyle had unknowingly accepted the offer, forming a binding contract. This is very important as the case highlights that a public advertisement with clear terms can be a valid offer, and anyone who performs the stated actions accepts it. So, the legal principle is that offers can be addressed to the general public and are accepted when the offer is acted upon by a member of the general public.